Hi, this week and next week we will talk about international personality. In other words, we will be studying subjects of international law. So we will first start with states and we will continue with international organizations, individuals and other non-state actors as subjects of international law. Despite the fact that states have traditionally been the primary subjects of international law and accepted as the only subjects of international law, this is no longer the case. So in this regard, what we focus on is international personality, which means that an entity is a subject of international law capable of possessing international rights and duties and has the capacity to maintain its rights by bringing international claims. So in this regard, a subject of international law, on the one hand, has responsibilities to the international community, in other words, duties, and on the other hand, it enjoys rights. So we said that the main subjects of international law are states, and for centuries, they were accepted as the only subjects of international law. The very reason for this is that states contribute to the formation of customary law, and they are generally accepted to be sovereign, that is, they do not need any other authority from above or from anyone else unless they choose to do so. With respect to states, in order to be able to consider an entity as a state, we have to look at the four components of statehood. The 1933 Montevideo Convention enlists the requirements of statehood as permanent population, defined territory, functioning government, and as capacity to enter into international relations. So, what are these four components? We said that the first is a permanent population. Considering that states are a totality of individuals, in order for an entity to be considered as a state, it needs to have a population, which is permanent and which multiplies itself. So in other words, how the population got to the territory is not an important question, because what matters is how this population multiplies itself. And this is due to the question of continuation of the state. On the other hand, how large the population is not necessarily important, and there is no defined minimum population. For example, while we can consider Liechtenstein with a 30,000 population as a state, we also consider China and India with a very large population as states as well. So the first criteria is a permanent population. The second one is territory. States are territorial units, and territorial sovereignty involves the exclusive right to display the activities of a state, as well as an obligation to protect within the territory the rights of other states, such as the right to territorial integrity and inviolability. On their defined territory, states exercise jurisdiction over all the inhabitants. And as for size, there is no minimum requirement for geographical size. And disputable borders do not negate statehood. What is important is the existence of a core territory. In other words, a state's territory may not be fully defined and there might be disputes with other states in terms of the exact limits of the territory. But if an entity has a defined core territory, undisputed core territory, then we can consider the territory component there. Our third component is effective government. An effective government that is independent of any other authority, which enjoys legislative and administrative competence, is a requirement for statehood. So this component mainly comes as a result of the colonial times and the independence of the state and the government being able to conduct its internal and external relations is an important component in that regard. So the main idea is that a state can be accepted as such only when it is in a position to guarantee that law and order will be upheld regardless of the type of the regime. So an effective government does not pertain to a specific sort of regime, but it refers to a control over the territory, being able to have a position to guarantee law and order for its population. In addition to the effective government component, an entity also needs to have capacity to enter into international relations with other states. What is important in here is that we are referring to a capacity to enter into international relations. So what we are referring to in here is different than the recognition of states and governments. This component was highly important during the period of colonialism, as colonized states were not independent in their external affairs. So they did not necessarily have a capacity to enter into international relations with other states because they were bound by the will of the colonizing state. While colonized territories enjoyed considerable autonomy in their internal affairs, they were typically not considered capable of entering into international relations with other states without consent from the metropolitan state, as in the example of India as a colony of Britain or the Philippines as a US colony. Here, we should make a distinction. With respect to federal states, this criteria makes it clear that the USA, for instance, for the purposes of international law, is a state. And its component elements, the states such as Texas, Arkansas, etc., these are not. So in that regard, federal states and what we refer to as states, as in the case of international law and international relations, there's a difference. Another important point is to distinguish capacity to enter into international relations from recognition of states and governments. The legal effects of the recognition of a state and government are different. The recognition of a state refers to a formal acknowledgement by another state that the entity has the attributes of statehood. So practically, this is an acknowledgement of the existence of the four components of statehood. The recognition of a government, on the other hand, means that the regime in question is considered to be an effective government by the recognizing government or the state. And in terms of state recognition, in terms of the differences between states recognition and government's recognition, the state recognition is a one-off act and cannot be withdrawn unless the state in question loses its attributes of statehood. But when we talk about recognition of governments, this can be withdrawn and it can happen in different ways. In general terms, when we speak of recognition, it is essentially a political act that is guided by political motivations. For instance, the example of Palestine. While some states recognize Palestine as a state, some others, like Israel or the United States, refrain from recognizing it. But in the meantime, Palestine can still be a member of the International Criminal Court as a state. If you look at the recognition of governments, it can take place in two ways, de jure and de facto. De jure means in or concerning law, and it refers to a legal recognition of the government in question and signifies that this government has risen to power in a legitimate way. So there is a full recognition in terms of the legitimacy of the existing government. On the other hand, de facto means concerning fact or in practice. It refers to a provisional, or in other words, a temporary recognition extended to the government, and signifies while a government may be in power and thus constitutes a negotiating partner for other states, the recognizing state is not necessarily very pleased with the way the government has come to power or is acting. So in situations where the state is reluctant about the government, for instance, if it has come to power with a military coup, then de facto recognition will be extended to this government. Different from the recognition of states, de facto and de jure recognition can be changed anytime. This can also change in accordance with the relations of the two states. And as we will see in the forthcoming weeks, this might be also a result of the reduction of diplomatic relations between two states. In general terms, when we talk about recognition, we should keep in mind that the value of recognition is symbolic. So one state accepts the other entity as one of its equals. Recognition reflects that understanding. Nevertheless, many states have relations with entities they are reluctant to recognize. Entering into treaty relations does not constitute implied recognition. For instance, if two states are members of the United Nations at the same time, it does not mean that they are automatically recognizing each other. Technically, recognition is a unilateral act, but it has effect on bilateral relations. So with this recognition, the state decides whether to have relations with the other state or not. While on the one hand, admission to the United Nations is seen as a collective recognition, it does not amount to individual recognition by each and every UN member state. And practically, if you put aside political disputes, etc., general understanding for recognition is that a state should only be recognized if it meets the political and legal criteria or requirements held dear by other states. So if a state can confine to these criteria, then recognition would be possible. Let's briefly talk about the outcomes, the results of non-recognition or the act of recognition. Recognition and non-recognition, first and foremost, affect the lives of individuals in that recognized or non-recognized states. Because practically passports to be accepted as valid or administrative acts to have effect, such as marriage acts, they need to be recognized by the other states. Otherwise, they will not be valid. In this regard, we also have to keep in mind the political aspects of the issue. Practically, a state may have all components of statehood, but this does not mean that recognition will be granted to it by all other states. The examples of South Sudan and Kosovo tell us two different stories. In the example of South Sudan, the new state was quickly recognized by other states as the secession of South Sudan from Sudan happened with a referendum that was recognized by the parent state. On the other hand, in the example of Kosovo, a much less number of states have recognized it, and there is still Security Council member states, such as Russia, that reject recognizing Kosovo. So, this concludes week 5. Please complete your reading assignments and take note of your questions, and I will see you in the live session. Take care.